finds that the inability of men to assume their wives' surnames constitutes differentiation.
I will never take the surname of my wife, never.
I think that this is a very important movement forward to equality.
I think it's brilliant. I think women have been suppressed by this for many years.
It's more like I'm not a man enough, you understand? So I can never allow that.
What's in a name? Or in this case, what's in a surname? It's topical and it starts right now. A very good evening to you, South Africa, those watching around the world. My name is Blaine Herman, and this is It's Topical. Our digital audience with us tonight. Remember, our digital audience is made up of members who have expressed a keen interest in our topic of discussion. So we invite them to be part of the show, to observe as well as to ask some questions to our guests. So please do get those virtual hands up. And as always, I'll do my very best to get you on air. Blaine Andre Pillay doesn't have the same ring to it, isn't it? But that's how it would have sounded if the recent Concord ruling was in play and I decided to take my wife's maiden name. Men will be able to assume their wives' surnames. For many, though, the consequences are far deeper than just the sound of your full name. But context is important here. This ruling was in the context of a civil marriage. It is your choice. I'll be honest, the ruling made me react in two ways, right? And this was in quick succession. First, hang on, there was a law that said I couldn't take my wife's surname if I wanted to. And second, take my wife's surname? And this split in reaction is seemingly the prevalent sentiment on the ground. People are divided on this matter, some for, some against. Now, Justice Leona Thron read out the judgment saying that the practice of women assuming their husband's surnames after marriage is rooted in patriarchal norms where women are seen as legally inferior to their husbands. The Constitutional Court declared parts of the Births and Deaths Registration Act invalid, saying that the law discriminated on the basis of gender. Now, the court went on to say that the impact on women is far-reaching. The symbolic consequence is that women's identities are subsumed into their husbands' families after marriage. Now this, according to the court, has the inevitable upshot of entrenching the notion that the husband is the head of the household. The court also went on to explain that this practice also perpetuates the historical philosophy that women are not equal to men and become akin to minors upon marriage. What do you think? What are the plausible consequences of such a ruling? What about customary marriages? What if someone is under customary law in South Africa? What sort of bearing will this have on them? We will discuss with the better minds in a short while. It leads us to the question of the week, and we ask you, what do you make of the Constitutional Court judgment that men can now legally adopt or hyphenate their wife's surname? Let us know at SABC News_TV. Let's head over to the Magic Wall, get you some context as always. A couple of questions comes to mind, right? To what extent does the Concord ruling challenge traditional norms here in South Africa? Also, to what extent does it go, how far does it go maybe, that's the better question, in terms of equaling the playing fields, gender equality? Let us know at SABC News_TV. Perspective coming up. All right, let's get you some context, and as always, let's turn to the magic wall, what we know and why it matters. SABC News senior reporter Kenny Mapanga joins me now, the better mind on this topic. Thank you so much indeed, Kenny, for joining us. Talk to us, let's take a few steps back and talk to us about the original act and what it said.
All right, so here we're dealing with Section 26, subsection 1A to C of the Births and Deaths Registration Act. That is when you want to assume a surname. That is what governs that particular process.
Right.
Now, it has always been in the context of women assuming the surnames of their husbands, but it does not cater for a husband or a male spouse wanting to assume the surname of their wife or a female spouse.
Right.
Now, the context in which you see this section being challenged is that, I guess for the first time in our constitutional democracy, you had two families that decided that their familial name would be the names of their wives. So in the context of Yana Joran and Henry van der Merwe, there's a specific in that Yana Joran is, I guess, the last standing member of her family, and she wanted to keep that legacy, keep that name. Together with her husband, they decided that Joran would be the family name.
Right.
However, when Henry van der Merwe approached the Department of Home Affairs to give effect to such a change or such an assumption of a surname, the system did not allow it.
Right.
And that is because it was prohibited by Section 26, subsection 1A to C. Similarly, with the Bornmans, you saw Jess Donnelly Bornman. She had hyphenated the surname, but the husband wanted to do the same so that they would carry the same family name. He was also prevented from doing so, and the legislation was cited by the Department of Home Affairs as to why he couldn't do that.
So, the order of constitutional invalidity by the High Court of South Africa in the Free State was then confirmed. Break down what the Court said, the Constitutional Court said in its ruling.
So when you get a order of, or declaration order of constitutional invalidity, for it to come into effect, you must get that same confirmation from the Constitutional Court. That is our apex court. They deal with these constitutional matters, and of course, if legislation is, I guess, invalidated on the basis of constitutionality, then the Constitutional Court must give the final say on such legislation. The Constitutional Court, in its analysis, found that there was no legitimate government purpose for this particular legislation. It found that the impact on women was quite insidious, and that it reinforced patriarchal gender norms that we've seen from our history, and of course didn't serve any legitimate purpose other than to subjugate women in their marriages. Another key finding was that how this legislation works is that it assumes or expects women to take on the surnames of their husbands, also risks erasing the woman's identity once they enter into marriage.
Right.
It infringes on the right to equality and the right to dignity, and it does so in an unjustifiable manner. So the legislation itself could not be allowed to stand because there's no legitimate purpose for this legislation to exist in our constitutional democracy.
Right.
So it was invalidated, or confirmation was given by the Constitutional Court, and of course Parliament has 24 months, that is 2 years, to remedy it. They'll choose how they do so. The court doesn't prescribe how Parliament must do its job.
Right.
So they could either amend the legislation or introduce new legislation to cater to the demands of our constitutional democracy today.
And they've got 24 months to do that.
24 months to do so, yeah.
Right. Now, that's the provisions of Section 26(1). When will it not apply?
In the context of?
In terms of whatever has been changed.
Yes.
What are the provisions under the new legislation under Section 26(1) does not apply when a person or assumes a spouse's surname after marriage or resumes a prior surname?
So you read it this way.
Right.
So what this declaration of invalidity does is that it gives you the right to choice.
Okay.
So if you are a family unit that decides you're going to be taking on the male spouse's surname as your family name, it doesn't affect you in any way. This Concord ruling, you have the choice to do so.
Right.
But if you make a choice as a family to state that you want to take on your wife's maiden name as a family name, or you want to hyphenate it onto your existing surname, there shouldn't be a legislation in place to limit you from doing so unjustifiably. So what it does is that it creates the right for choice without any limitations. It's not imposed on any families or any marriages that don't want to use the maiden name. You are free to do so. You have that choice.
Yeah.
But what the court is indirectly saying is that for those that want to exercise their rights to have their wife's surname, there shouldn't be any limitations or prohibitions on that are unconstitutional, that stand in the way when they approach a Department of Home Affairs to give effect to such a desire.
What about the bearing on customary marriages?
So customary marriages are different in nature and they have their own rules that govern it. So once again, if you are a family that chooses that this is how the rite of passage of marriage follows this particular process and you accept it, it shouldn't affect you in any way. But if you're a family that chooses that you want to take on a particular surname, this is catered for those people that have that desire and shouldn't have any limitations in law that stop them from doing so, because it has been declared by the Constitutional Court as unconstitutional.
Context always important. Kenny, thank you very much indeed. SABC News reporter, senior reporter Kenny Mapanga there. We're going to take a quick break. Discussion up next. It's a hot topic, right? The changing of surnames or taking your wife's surname. It's topical, so we need to discuss this. To help me break down this ruling from the Constitutional Court, we have Khaya Ndwandwe, cultural expert. We also have Advocate Brenda Madumise-Pajibo, Wise4Afrika Director. Thank you very much indeed. Social Commentator Kwanele Ndlovu is with us as well. And Thabo Masombuka is a senior legal practitioner. Thank you very much indeed, ladies and gentlemen, for joining us. Khaya, maybe I can start with you. Why do you think this Constitutional Court has unleashed such angst among some men?
Greeting in my panel. It's a critical story, my brother. Actually, I'm the Zulu. So to us, my surname is a critical thing to deal with. So that's why it doesn't sound clearly to us how to apply this thing. Let me make an example. My surname is Ndwandwe. So I've got my grandfather, as you know, that Shaga Ilembe, Zwite, Galanga Mkachwa, it's go down like that. So now what we are seeing, what we are looking for now is that it looks like it's going to cut our genealogy, unless they might come up with something else, because my son must use my surname. My son can't be Mkwanazi because my wife, she's Mkwanazi lady. So there is that genealogy that we are so critical about it. That's why we've got two types of people. We've got another, someone must be, actually according to our culture, we are not allowed to have a child outside the wedlock, but things go randomly because they are trying by all means to protect the surname. The surname is a great thing to us, and so that's why there is that friction among us.
Advocate Brenda, you shaking your head vigorously. Disagree?
Completely. I think what we need to start working on is delinking names to matrimonial regime or marriage itself, right? Because that's the problem, right? When he says I'm a Mkwanazi and Ndwandwe, there is something about that, right? That strips his wife of that identity, because that child of theirs is part Mkwanazi and Ndwandwe. So you can't erase it, right? And I think we're bringing culture where it's not necessary in this case. And let me explain why I'm saying what I'm saying. And I don't understand the meltdown from men in particular. But let's be clear that the meltdown is not just men. There's been many women, some being lawyers for themselves, who are in an ICU because of this decision, right? What this gives us, and if we are true to ourselves as Africans, that we believe and we live in a constitutional democracy that gives you and I the right to choose, the right to have choice. This is what this decision has given all of us, that I can decide tomorrow that I want to continue with the lineage, not just of the Ndwandwes, not just of the Mkonazis, but the rest of my lineage that defines who I am, right? Yeah. And it's about that, right? And I don't want us to bring culture where it's not necessary, because what has happened here is that we're bringing this law in line with the Constitution. If we believe in equality as a country, we espouse provisions of Section 9 of the Constitution, the right to equality, right? So if you give to the right, it must happen to the left, right? And that's all that has happened here.
Right.
That I, as a woman, for the longest of time, I could not choose. Automatically, when I got married, Home Affairs changed my surname without my consent, right? Now, it has changed that I decide whether I stay with my surname, whether I take my spouse or partner's surname, right? Give the same to the man if they choose to do so. Finally, we all know that it has been a struggle for many parents to travel with their children if the surname is different, and you demand affidavits and all of that. This helps many families when they travel, that they don't have to be stopped because they think that you are trafficking children. It gives me the opportunity to say, this child is mine, she or he is carrying my surname because I'm part of it. So I think there's no need for this meltdown. There's no need for this, even that for us to be sitting on this panel to have this conversation. Because really, if we live in a country that we say we live in, it's about constitutional democracy, about choice, come on.
Kwanele, I wonder if we are putting too much stock into a surname. I was reading Makudu Safara's column today in the Sunday Times, talking about the history of surnames and how banal it was, giving the example of Spain in the 1930s, where citizens were asked to have a surname because of census and tax collections. Are we putting too much stock into it?
Hi, good evening. Yes, definitely I believe that we are. The whole farce is just an overstretch because the surnames, especially for us South Africans, they are an import themselves, and we have learned to live with them. And I believe that the law will then allow people that do not want to be forced into a surname after marriage to have a choice of which surname they want to choose. And actually I would want to disagree with Mr. Ndwandwe here about the cultural erosion of the law, because after all, we live in a secular country. South Africa does not necessarily cater for his culture as a Zulu person. It must cater for other people who want equality in then gaining surnames that they marry into, being men or not. So it will be very narrow-minded to look at it from only a cultural perspective and then say that you disagree with it, because I mean religious people also have their own way of doing marriage and how they live and choose surnames. So at the end of the day, should you choose and you say that your custom doesn't mind that you take on that surname, you now fortunately have that choice. And it's not being force-fed to anyone that believes that culturally they do not want to adopt the law itself. So, and also I believe that the whole argument shouldn't be about gender. It should be about equality. You know, it shouldn't be as men. People should be looking at everyone as well, if we are seeing each other as humans and we say that women should be taking a surname, why can't men do the same?
Does the judgment, Thabo, touch on that or make it explicit? I was just looking at what Justice Thron said. As part of the judgment, she said that the custom that a wife takes the husband's surname existed in Roman Dutch law. And in this way was introduced into South Africa's common law. And it goes on to say that this custom also came into existence as a result of legislation that was introduced by countries that colonized African countries south of the Sahara. Help us understand the thought process that the judges went through.
Thank you very much, and good evening to you and the viewers at home and our fellow panelists. At the core of this judgment and this expression is the validity of Section 26, subsection 2 of the Births and Death and Registry Act. So what the court, and what is important that we need to mention here is the fact that, which is very compelling and instructive, is the fact that the court was unanimous. You see, once the court is unanimous, it tells you that the full expression of the interpretation was under no circumstances doubtful. But here's the thing, never did we ever think that in our constitutional dispensation will we have a judgment like this that has actually touched us in our studios, right?
Yeah.
Social media was a buzz this week. But you have to understand, the reason and rationality of why most South African, and coincidentally it's been men, who's actually been expressing a completely disturbed opinion about this. You know why? Because this has been a generally accepted practice that once you get married, you invite the wife into, as a head of the household, into your family. But what this judgment then does, it actually says, because I can tell you now, if you didn't see it as taking a wife's surname, but taking a partner's surname, are you aware that the emotionality changes immediately? It changes immediately because what this judgment actually does, it doesn't really prohibit anything, it only elevates and remove the subjudication, insubordination, and the inferiority complex attached to women being partners in marriages. That's all that it does. It actually allows the choice. And your senior reporter made it explicitly clear that the effect and the implication of this constitutional invalidity finding is that it now provides an option. And people should not really be worked out, because if you really do want to recognize that in a marriage form, because let's be honest, whether how you describe and call yourself in a marriage doesn't change the legal consequences of a marriage, does it?
No, it doesn't.
It doesn't. So this judgment actually promotes that and puts that at the center. So I think South Africans have got to accept that the evolution of society, the change and the improvement in our living standard. Can I make an example?
Go ahead.
Does me and you ever would have ever thought that corporal punishment would have been banned in this country?
I hear you.
We never thought that, because me and you probably grew under an environment and circumstances where our parents were smashing us when we were young. But you do that now, you actually will be found wanting. You know why? Some families still feel, Babu Ndwandwe, that the punishment of corporal punishment erodes the parental responsibility to instill discipline in our child. But here's the reality, is the fact that it has been punished because of these constitutional implications.
Khaya, the court also said that in many African cultures, women retain their birth names after marriage, and children often took their mother's clan names. And it went on to say that there are several historical and cultural authorities that suggest this is evidenced by traditional African cultures, customary law in many African countries, colonial records, and accounts from the 18th and 19th centuries, missionary records from the same period, and oral traditions. Does that change your perspective on how you see this ruling?
Yes. Let me put it clear. In our culture, we've got two important events. Once you pay lobolo, there is the event that they call it umkhehlo, where you honor that lady that now she's going to be out of your family, is going to be Ndwandwe's family. It's very, very important. In umkhehlo, you see there is that hat they used to wear, but now it's fashionable. Actually, before it was not for everyone. It was for somebody who was already paid ilobolo. It's like an engagement. Secondly, we have got what we call iscawu. Let me make an example with myself. I was born out of wedlock. My mom doesn't have a iscawu, so I don't qualify to inherit what my father have. But somebody, my younger brother, because here mother is there, he have got what we call iscawu. What's happening at iscawini is where they say they combine the ancestors. So they surrender the lady to the ancestors of Ndwandwe. As from now, she belonged to Ndwandwe. That's an important event, iscawu. Iscawu is not to be used to be inside the home because of some reason, some other ancestors is not spiritually purified because of some different reason. That's why it's used to be somewhere outside. It's what we call iscawu. So that thing, it's like it's a proper marriage, because they used to say umfazi wesiccawu. So once you are there at Esigcawini, you are belong to Ndwandwe's family in a full force. That's a culture that binds us. So now, if we want to change something, it's where we started to open our eyes and ask different questions.
Go on, Advocate, before I ask a follow-up.
And I think if we feel strongly that our culture is under attack, right? Whether it's a Xhosa culture or Zulu or Sotho culture, if it's under attack, you had an opportunity to be amicus curiae in the matter, right? And put the argument forward, right? So I would have expected him as Ndwandwe to do that and be able to force the Constitutional Court to reckon with that aspect of tradition and culture. And maybe they would have really dug deep into colonialism and cultural self. So I think it's a calling to all of us to not sit back and just look at the Constitution in a vacuum. It's a living document that has to be tested all the time, right? That must produce certain results and be part of formulating the jurisprudence in this country. So once there is a decision already, right? It happened in the High Court in Bloemfontein. There was an opportunity for most people who, I can see the comments coming from your viewers, right? It's about culture, you're destroying black culture and all of that. And I want to challenge all of them. How is this judgment destroying black culture, right? When you are sitting back and not testing that constitution to be able to emulate the very same culture that you're talking about. So once other citizens, remember, she talked about, Kwanele talked about that we are a secular country. It represents many diverse individuals. So when you talk about equality in this country, it has to be multidimensional, right? It has to be transformative, right? What are we talking about when we talk about equality? It's substantive equality that not just looks at formal equality, but looks at my lived experience as a black woman in this country, that looks at his experience as a black man in this country, and an Indian man in this country, and white man in this country, and a white woman in this country. And that we bring it to the Constitutional Court to test where this document lives to the aspirations for all of us.
Right. Let me go to the digital audience. Kai, I'll come back to you in a short while. I just want to get a few questions from them. Zipazonke, I saw your hand up first there. Let's take you.
Thank you very much. I'm very disappointed in the panel's conversation there. Because it's the conversation is very limited. You guys are just looking at it from a point of view of the rights of a woman in a marriage institution. Marriage institution means individuals are together as one whole, not as separate entities within this thing called a marriage. And you have to go back to natural law. You know, there's always an argument in law between natural law and human law, legal positivism. And natural law, which you would find this principle of lineage, exists from an accountability point of view. It seeks to create accountability to society to say, okay, when this child is born in this marriage institution, this child, we already know that who the mother is because the baby comes out of the mother's stomach. But now we need to find a way to identify who the father of the child is. And the way we can create that accountability within society is to then say, okay, we need to name this child after the father because the mother's already known. It's an obvious fact. It's a moot point. So from a natural law point of view, you have to create a system of accountability. Now, when you bring in equality into it, if the equality undermines the natural law, then the equality is not good enough. That equality has to go away. It undermines natural law. The natural law supersedes the human law. I'll just make a stupid example because sometimes you have to do extreme examples. If there was a human law that said, guys, don't care about gravity tomorrow. From tomorrow, we don't care about the laws of gravity. Natural law is going to say, okay, do that, but you're going to die if you jump off a building. So meaning what? Meaning that if there are principles that are hindered in natural law, you cannot have laws like this that come to seek to open the gap. You need to bridge that gap, and that's how you create harmony in society.
But thank you.
And sometimes giving people choice is detrimental to society.
Giving people choice is detrimental to society. Kwanele, how do you respond to that?
I totally disagree with him. Giving people choice is actually the pillar of equality, and it then brings us a very healthy democracy. And the natural law that he speaks of is something that was developed and it evolves. And I would say actually this development in our law is also another opportunity for us to develop ourselves and look at how exactly have we been lacking in achieving equality. Because if you think about it, also the law that we are talking about, the registration of births and deaths, it was written in 1992. It was written in 1992 before our democracy.
Right.
So it was about time that it was tested and it was corrected and brought to be in line with our constitution. And that will be done even in the future, because this is not going to be a law forever. Should we go on and the next generation believes that, no, this is how now we want everybody to live, and there's agreement in future that everybody must carry a dual surname. That will be done if it goes to court and it passes the test of equality.
Yeah, correct, you're correct. I mean, for an example, I don't know what is natural law. In fact,
Thank you.
No, in fact, the problem with stupid example is that they're exactly that.
Yeah.
But that's not an issue here. The issue is that if you look at what happened, and the advocate is correct, the court did not impose itself on this. This is a matter brought to court for a directive. So it was held in the Free State High Court, where the parties were successful. It was referred to the Constitutional Court for a certificate and a declaration of validity. And one of the other implications of this declaration of validity is that it now provides partners, and I keep on saying partners because I want to elevate the importance of what Mhlongo is talking about, that parties and partners, spouses in a relationship, spouses in a marriage, are supposed to assume equal status, so that the children born out of that, because they are created by both partners, need to actually have the appropriation and recognition of that. So if this law said if this ruling said men must now adopt surnames of their wives, would have been having a different conversation. But it would not have said that, because all that it was doing was interpreting the implications of an equality provision in relation to the Births and Deaths Registry Act. And it has found that that does not pass the test of constitutional scrutiny.
Khaya, is it just a misinterpretation or misunderstanding of what the court actually said that people are getting worked up about it?
To us, I'll keep on saying, because I'm a cultural expert, so it's look like it's going to dilute our culture, because we strongly believe in the thing that, no, the court done something which violate our culture, the way we look at it. So that's why I receive a lot of calls. People, they say, as if I was the part and parcel of that. I was happy because even the leader of the Contralesa, he says he's willing to challenge, as Madam did say, we must go to court and challenge. I think now we have to prepare something and go to the court and prepare and say that, no, we are not happy with this law, so that we can test it. Because we see that some loopholes in our families. For example, let me take an example. Now we've got people that are coming from faraway countries. If that person come and take my sister and become Ndwandwe, it will be a disaster, because one day he must go so it's out.
I want to get you, but go ahead, Kwanele.
I have to respond to Mr. Ndwandwe. Actually, I'll touch on two things that he said. The first one, let me speak about the Contralesa now deciding that they will go and challenge. Unfortunately, it's too late, because this is not a new. This is not a new thing. It was all over the news even last year. Contralesa did not stand up, which actually gives a picture that they maybe aren't as concerned about culture and its erosion as they now come up to say they are, because there was an amicus curiae in the case, but it had nothing to do with culture. It had nothing to do with
they're not here to defend themselves, so we're hoping to get their take as well on this. And your second
he spoke on their behalf, that's why I was responding to that. However, the second thing, I feel that if he has so much fear about culture being disturbed or being by the judgment, then this maybe brings an opportunity for cultural experts, cultural traditional leaders, the likes of your organization, to then fortify your culture, make it fashionable, make sure that whoever believes that they are so cultural that this is this would be an insult to their ancestors, then they do not follow that law, because at the end of the day you would have chosen yourself, knowing what your culture and custom is, to change your surname and make it of your wife. Maybe it's a teachable moment for everybody to then reinstate the love of culture in every one of their members.
Yeah, but there is a window of opportunity. Remember what the implication of this judgment also say is that within 24 months Parliament is directed to actually cure those provisions of the Birth and Death Register Act that are rendered unconstitutionally invalid, so that Parliament will then engage in what is called a lawmaking process, which involves consultation with stakeholders, which involves those partners that are feeling aggrieved as a result of this. But I think central and fundamental to this is the issue of choice and option.
Yes.
Zippo Zonke, thank you very much indeed for your question. There's no silly questions, by the way, so your input is valid and worth your comment on this program. Utando, talk to us. Your question, comment.
Good evening, Blaine, and good evening, everyone. Thank you for the opportunity. It would be possibly an administrative and generational nightmare tracking people's true ethnicities, nationalities, races, kinship, but all this to say that giving one's surname has always been something that should be done intentionally with a lot of thought behind it. It's not so much about gatekeeping certain surnames, but it's helpful in creating systems that make understanding the environment around us easier. Taking on a surname isn't just an act of love, it's privilege, honor, and duty to all those who hold it. This discussion has been taking place from a heteronormative lens, with confusion around what traditional gender roles and expectations within families would look like if men take women's surnames. But as we've all experienced in different ways, the lines had been blurred long before this week, where a woman would pay their own lobol. The more important aspect, however, is access to certain privileges. The growing concern the public has about safeguarding South African surnames against foreigners is unfortunate, but somewhat reasonable if we look at the chaos we have with stolen South African identities. People seldom take care of things they don't have a connection to, so abusing the power of a surname because of the doors it can open for you is likely, but this happens even with South Africans taking other South African surnames. This debate also simultaneously undermines South African women's ability to make decisions logically instead of emotionally. I'd like to believe that South African women would use their critical thinking skills to assess their situation. It would be interesting to see how it all plays out, but if it's understood by everyone that there is a great responsibility in giving a surname, South Africa isn't going to go down in flames as people are declaring.
Utando, thank you very much indeed for your contribution. Luke, let's hear from you. Go ahead.
Hi, everybody can hear me, right?
Yes, loud and clear. Go ahead.
Perfect. I think it's something that's very interesting and what Mr. Ndwandwe pointed to, and that's with this ruling, like beyond the debate about where the confines of culture begin and end and what the legitimacy of taking these names are, there's a couple things. There's one, how inheritance gets applied, because so long as we have the cases where inheritance particularly in some traditional cultures, comes through a male line, where do we find that equality between looking to preserve our cultural practices and also ensure the equal rights of women? That, although we've, put down the legal case to make those names equal in adoption now, figuring out where equality works in with there will be difficult. And then the second thing is, now we have a practice where beyond taking away the fact that it's a woman's name now being able to be taken instead of the man's last name, there's also the interesting thing of now we have two surnames to choose from within couples, and that creates the question of, will we see a potential hierarchy of surnames and how will that apply? If you have mom and dad, one's last name is Oliphant, one's last name is Ndlovu, are we going to see a particular issue around culture where, I don't know, for the sake of our kids, would it be better to put Oliphant as that last name instead of Ndlovu? Will that affect their chances of getting a job? How will that affect them culturally? So that leads into the interesting question of, where do we prioritize certain surnames if we are going to see beyond the egos of male versus female inheritance of that name?
Thanks, Luke. We'll get some comments from the panel in a short while. Kustas, let's hear from you. Then Noel. Kustas?
Thank you very much, Blaine. I think the discontent or the uproar comes from the fact that we have been unhappy for quite a long time with the decision that comes out of that Concord. This is not the first of many decisions that have made us very, very unhappy. With that said, I want to say that I'm hoping that Parliament will address the issue of cultural matters. And I hear that your guests seem to be putting the culture down. Culture is part of who we are. So when you make these decisions such as this, you cannot exclude the cultural norms or how things are happening in the country. So I'm hoping then that Parliament is going to make sure that we are satisfied from a cultural perspective that there is a balance there.
Right.
But having said that, this Concord and its decisions, I'm very unhappy with some of them. But this one, hopefully Parliament will make a balance so that we're all content. At the moment, I don't have a problem with what was said, but it's quite interesting.
Thanks, Kustas. Let's hear from Noel.
Good evening, Blaine, and to the viewers at home. I think that the Concord's ruling is a landmark for gender equality in South Africa by striking down restrictive provisions in the Birth and Death Registration Act. It allows men, just like women, to adopt or hyphenate their spouse's surname. This will affirm the Concord's or the Constitution's values of fairness and dignity while giving couples the freedom to define their family identity in ways that reflect modern egalitarian values. However, I think it's important to also reflect on the cultural dimension. Across many of our communities, a father's surname serves as a vital link to family heritage, continuity, and belonging.
Right.
Even a woman's surname traces back to paternal lineage, showing how deeply these naming practices are tied to our traditions. In some customary systems, the surname can determine legacy, clan affiliation, and social roles. Allowing men to take or change their surname in this way could complicate those structures, raising questions about stability and clarity in family lineage. So while I welcome the broader choices this ruling introduces, I believe future legislative reforms must strike a careful balance, upholding individual autonomy while safeguarding cultural traditions.
Right.
If handled thoughtfully, this moment can advance equality without eroding the heritage that fortifies our diverse society.
Right.
This ruling is a victory for equality, but its success will ultimately depend on how we balance personal freedom with the preservation of cultural heritage.
Right.
So that progress strengthens and fragments our society.
Noel, thank you very much indeed. Advocate Brenda, I think possibly legislation is one part of it, but there needs to be other conversations if there is going to be a mindset change going into it. Widely accepted expectation now is that my wife will take my surname, Herman. If she doesn't, it might be seen as disrespect. It might be seen as she not blending into my family. How do you change? How do you counter that expectation in this day and age?
How do we counter men believing that they are in control of women's bodies? So we have to have this conversation and not limit it to this discussion, because if we're talking about redressing and addressing patriarchy, addressing power and control, and looking at systems and institutions and systemic issues that we deal with around equality, around discrimination, around formal and substantive equality, we can't be pedestrian in our analysis, right? So if this is an opportunity for us to expand and just talk about how men view women, how the default in everything that we do around the world, the default is the man, then let's go deep into how this privilege of you being a man has given you the opportunities and the privileges that you have, that I have to take your surname whether I like it or not, and that we cannot have that conversation that he spoke about, one of the panelists online, that it's two people that must have this conversation. Let's go deep in having those conversations and talk about how culture has subjugated women, has taken away certain rights away from women, right? So I'm ready for that conversation to happen, and it can happen superficially, right? It can happen because we feel that our manhood has been taken away because of a surname. It can't be about the surname. Let's go deep into why is it that he's feeling the way he's feeling, right? Because it can't be that it's just the surname. Let's be honest about why is it that we feel so slighted by this decision. What is it that is making us? Are we losing control? Do we think we are losing control as men? We're losing the power that we think we have had for such a long time? So please, can we be honest about why is it that we're feeling like the world is about to cave in on us?
Okay. I fully understand, Ms. Brenda. The only thing is that we respect women. If you say how men view women, we do respect. For example, in our village, if you are we've got maybe we will find that 10 families of Ndwandwe, just one surname. If you are saying I'm going to Ndwandwe, they will ask who. But simple way, you will say Ngiyakuka Mkhwanasi. You see now, my wife's surname dominate because she's the one who's prominent now. We are 9 at home. We've got luckily 9 wives. My brothers, up to younger brother. All of us were married. So if you say Ndwandwe, which Ndwandwe? But simple answer, no, I'm going to Mama Mkhwanasi, but to go there. We do respect women because we give them, even you can go to the Royal Palace, you can find a woman like Ogamsweli, Omkabayi. We give them that respect they're supposed to receive. The problem is that now, if I change my surname back to Mkhwanasi, it doesn't sound so nicely because it's regarded as if it's no more there. It's now it belongs to Ndwandwe. So it's where now it clashes with our culture. It's how we feel that no, something they invade our culture when it comes to that position.
Kwanele, I'll get your thoughts in a short while. I just want to give our viewers a sense of what people out there are thinking as well. A regular word on the street feature took to various streets of Johannesburg to seek these diverse perspectives and insights on this topic. And this is what people had to say. Take a look.
We live in a very progressive society, so I guess why not? But I guess it's also quite a tricky one, you know. But I think having been married quite a long time myself, I think you face much bigger challenges in your marriage than just a surname. So I think it's up to the partners that get married.
So the identity of a person, of a children, that come from the man. So if I take my wife's name, imagine now I had to change and become someone else. So the whole identity of my family, the roots, is lost. Surname is my originality. Even for my next generation, they must know where do they come from. I will never take the surname of my wife, never.
Now, if we look at the Constitution, it actually says that all people are equal before the law. And the argument that they brought is that if men can't change their surnames, they aren't treated equally even if they are married. So I think that this is a step forward. There might be some backlash from various people in the field. There might be some academics that says that it should be declared unconstitutional. But I think that this is a very important movement forward to equality.
I think women have been suppressed by this for many years, so it's time that males understand what we had to do or go through. It's not a simple thing as just taking over a surname. It's an entire identity that you lose and a new one that you gain. So I think it's fair that males experience it as well.
Let's be honest, we all want change. From a modern point of view, it's nice that men can now take something because from a female point of view, we change a lot. But when you think of it from a traditional aspect, hey, it's a bit complex now.
As a man, you need to grow your surname, and it's something that in the past never happened from our great-grandfathers, so they've never experienced such a thing.
I personally wouldn't take my wife's surname just to preserve my heritage, my culture, my lineage.
Conversations even continuing as that insert played. Thank you so much indeed for your comments. Kwanele, talk to us about some of your thoughts.
In fact, I wanted to comment on what Mr. Ndwandwe said earlier. about perhaps foreigners coming in and taking his surname and how that would be inappropriate according to culture. And that made me think of actually, there's people in the country, and I believe people from the Eastern Cape mostly call surnames that are not theirs, because there's a difference between Istuwo and Isfani. However, they know and understand their ancestral roots, and when they do their imisamo, they then lean towards that identity. So it doesn't take away their identity at all that they are called September. And there's even a person by the name of Paraffin. However, his ancestral identity and his core identity still continues, regardless of what he is called on the register, the population register. And also what Mr. Ndwandwe was concerned about, actually, you asked a question which I found interesting, that how do we counter the current attitudes that people have with how or the authority that the surnames carry. And the example that was made is that it is expected that a woman would take automatically, would take the husband's surname. However, that was already counted. There's a law that was passed in the past that changed that. So we counter it in the very same way. We use laws to change things that that need to change in society. So if we were able to change for women to automatically assume the husband's surname, and we again lived, and it is now a norm for actually a woman can choose whether to retain her surname or to use the husband's surname. So we will also eventually get men that accept and choose to whether they take the surname of the wife or not. And Luke also touched on the whole issue of a child, whether the child takes the father's surname or not. That was also counted by a law, because by law, whether you're married or not, you get to choose whether your child takes the father's surname or the mother's surname, or you double barrel the child's surname. The only the only issue that had not been corrected thus far was the issue of the men taking the surname, and it has now finally been covered. And fortunately for those who choose, like one of the audiences that were spoken to on the insert that you've just played, so people can choose. Some of them said, I would never do that, which opens up a choice for the likes of Mr. Ndwandwe and Mr. Mhlongwe. And there are people who would choose to do so. And those are the people that went to court and approached for the freedom to do that.
Thabo, I'm going to come back to you in a short while, but Khaya, I mean, for people who have made up their minds on this issue, it's going to be a tough sell to change their minds, right? But I wonder, will that change in the next 5 to 10 years, given if the law is, at play? I wonder if we're going to look back 10 years from now and say, what was the big fuss all about?
Yeah, actually, before there was no cell phone. When cell phone came, we thought it's for the millionaires. So once we were having a cell phone, we thought we are a millionaire. But when times go on, it's become fashionable. I think I have to agree that along the way, there will be some changes. But as from now, it can't sound clearly. Because even in our culture, we are divided. We have got Christian and non-Christian, you see. Some other people, they went for it, some others, they did not. So you see that balance now. Some other people, they can say, no, it doesn't matter, let me go for it. Take, for example, at home, we are so divided, but if we're at home, we've got only one mind because we respect the dignity of that family. But somebody can come and say, no, this is my right, you see. What I can say, along the way, we might see some differences, because in Isizulu, we have got idiomatic expressions that say we can't go in a one-way side like water. So we have to be divided always. People are not like water. So I'm expecting that some other people, they'll say, no, they see no problem, as the law say, it's a choice. If somebody's saying it's my choice, it's a choice. So we can't ban that person in that family.
Thabo, this is what the court had said in the judgment. It said, in parts of Africa, the tradition of a woman assuming her husband's surname is rooted in colonialism, religion and patriarchal cultural norms. With the arrival of the European colonizers, I'm quoting verbatim here, and Christian missionaries, and the imposition of Western values, the tradition of women taking their husband's surname was introduced. Does the judgment strike a balance between surname stability and also not affecting freedoms as well?
It does. It does in many ways, in the sense that, and I will emphasize colonial and patriarchal, because I think what is important here, which this judgment does, if there's anything that this judgment erodes, is the dominance of patriarchy. That's all that it does, because there's a much more bigger conversation to be had here. And the surname is just the one issue.
Yeah.
But the other issue is about perseverance, recognition of the equal role and standing of human beings. 2006, this country there was also a cultural uproar when the Civil Unions Act was promulgated. You remember that?
Yeah.
That recognized the marriages by same-sex individuals. 26 years later,
We are okay?
we have all moved on.
Yeah.
That's the evolution that we've talking about. Because what is critical here is that South Africans need to disabuse themselves from the culture of intolerance.
Right. We'll have to leave it there. I'm told time is up, but look, this conversation will continue, right?
Yeah.
We've got 24 months in terms of public hearings or people having their say in terms of the formulation of this legislation. Thank you so much indeed. Value added, no doubt, to our panel. Digital audience, appreciate your time. Thank you so much indeed for joining us tonight. Okay, before we go, here's my take. Choice. It suggests the opportunity or privilege of choosing freely, freedom of choice, right? Option implies a power to choose that is specifically granted or guaranteed, and that's the dictionary meaning. But it depends if you value choice. This constitutional court order has struck a nerve with many, and for various reasons. It challenges traditional norms, but it also does something else. It starts a conversation, and whether you are for or against taking your wife's surname, it gets us talking to one another. And once again, there's an opportunity to make conversation part of the cure and hopefully get to a better place as a nation, as a society. Look, change can be uncomfortable. As humans, we are wired to finding comfort in the familiar. So the fear of the unknown freaks us out. Yes, change can be uncomfortable, but is it necessary? I can't answer that question for you. In this situation, it is for you and your partner to decide. It's your choice, and that's my take. If you miss anything on this program, then be sure to watch this episode of It's Topical on YouTube, as well as SABC Plus. If you're watching a repeat of this program, then as always, the news continues. Unwrap Africa up next with Tembekile, followed by G20 Focus with Tulasizwe Similani at 8:30 tonight, so stay tuned for that. Until next week, my brothers and sisters, take care. Bye-bye.